So you walked into the courtroom thinking you were handling a child custody dispute, but you were not. You were looking at child psychological abuse case, and nobody in that courtroom knew how to name it correctly. Not the evaluator or the guardian ad litem, the therapist. All these people have been seeing the family for 2 years or more and had no idea what was going on. And I want to change that today. I'm Dorcy Pruter. I've been working in family reunification successfully for over 20 years. I introduced the Childress framework to hundreds of professionals, attorneys, family courts across the country. And today I'm going to give you what nobody else in the space has given you: a complete clinical and legal roadmap for what you are actually looking at and how to prove it in court and what the remedy actually is. So let's dive in. The single most important shift an attorney or professional can make in these cases is to stop thinking about it as a custody issue. It's a child protection issue. Those two frameworks produce completely different outcomes in a courtroom. And the custody frame asks, who should the child live with? And a child protection frame asks, who is harming the child and how do we stop it? Dr. Craig Childress, he's a PsyD. He identified clearly in his clinical framework on what is called pathogenic parenting. His framework does not ask the court to choose between parents. It asks the court to identify whether a specific form of child psychological abuse is occurring and to respond to the way it would respond in any other form of confirmed child abuse. So, when the three diagnostic indicators of pathogenic parenting are present, the correct DSM 5 diagnosis is V995.51, child psychological abuse confirmed, not parental alienation, not high conflict divorce, not a difficult custody situation, child psychological abuse confirmed. Now, this is the frame that changes everything in a courtroom. And that is the frame that this episode is going to teach you to use. So, before you can argue child protection in a courtroom, you need to know what you're actually looking at. And the Childress diagnostic framework gives you three diagnostic indicators that must all be present. Indicator one is an attachment system suppression. The child is displaying a selective, targeted suppression of a normal range functioning of their attachment bonding motivation towards the rejected parent. In plain English, a child who previously had a loving relationship with a parent is now seeking to completely terminate the relationship with no legitimate basis. The second criterion is really important. The targeted rejected parent must be assessed as broadly normal range. If the targeted rejected parent is actually abusive, this is a different clinical situation. It's a differential diagnosis. But you have to actually know what child abuse is, because what I see a lot is people just assume when a child says something or the other parent says something that that's child abuse when in actuality it's not. Then indicator two is either a personality disorder trait or phobic anxiety displayed towards the rejected parent. Personality disorder features the five specific symptoms: grandiosity, absence of empathy, entitlement, haughty and arrogant attitude, and splitting. Splitting is the idolization of one parent as all good, while the other parent is entirely devalued and all bad with no nuance. And these features, really displayed by the child towards a parent, are not normal child behavior. They are clinical symptoms of conditional pathology. And the indicator three, the fixed and false belief, the child holds a fixed and false belief regarding the fundamental parental inadequacies of the rejected parent. And they're characterizing that relationship as emotionally or psychologically abusive, despite the absence of substantiated basis of that characterization. So all three must be present. And when they are, there's a DSM 5 diagnosis, V995.51, child psychological abuse confirmed. That's the diagnosis. And that is what you argue in court. The problem is Most of you, lawyers and guardian ad litems and people in the family court system, are getting caught in a loop of a rote way of behaving using standard custody evaluations. And here's the problem: attorneys need to understand that standard custody evaluations are an abomination. And Childress has been directly advocating against these for years. He writes about it in his clinical writing, and no studies have ever established scientific validity of the conclusions reached through the standard custody evaluation. They involve extensive data collection, followed by conclusions based primarily on clinical judgment, and clinical judgment that has never been validated scientifically in this context. So, opposing counsels opening every time a custody evaluation is used as the primary evidence is it's expensive, it's time consuming, and it's vulnerable to challenge. The single case ABAB reversal design gives you something fundamentally different. It is a scientifically established research protocol with a specific empirical structure that can definitively establish both causality and treatment efficacies in an individual case. I've used the ABAB single case design method over and over and over again in these cases. So it's not a new idea. The ABAB single case design is the same research methodology used to evaluate behavioral treatments for autism spectrum disorder, educational interventions. It was favored by the research model of B.F. Skinner, and it has established scientific validity. So when we apply these cases, it gives the court something it has never had before: empirically driven evidence of causality, not a clinician's opinion, actual behavioral data collected systematically across structured phases that shows definitively whether the allied parent has influence, and the influence is creating the child's symptomatic rejection of the other parent. And that evidence is defensible in court in a way that clinical judgment alone is not. So I want to walk you through the structure so you understand what you're arguing for when you're arguing to use this protocol. So the ABAB single case design has four sequential phases. A1, this is the initial baseline period. This is the assessment of the child's behavior while still being exposed to the pathogenic parent's influence, and the daily ratings are collected using the relationship rating scales. And the link is in the show notes, so feel free to download the relationship rating scales and the short overview of the ABAB single case design. You can also buy the book. Dr. Childress has a small book on Amazon. So the rating scales measures the child's attitude from hostile to affectionate, cooperative to defiant, and from withdrawn and engaged. So if you have this baseline, this is what the pathogenic parenting looks like in measurable behavior within the child. And so the B1, this is the second phase, is the initial intervention period. The child is protectively separated from the pathogenic parenting influences of the allied parent. All contact between the allied parent and the child is prohibited during this period. And the intervention begins maybe with the high road to family reunification, a 4-day intensive psychoeducational intervention developed by me. And this program that Dr. Childress formally reviewed and documented, he recommends this because he's watched me facilitate it. He's taken a child into maintenance care after a high road. The child's behavior is rated daily throughout this period. So before the workshop or 90-day no contact, and then after. Then we reintroduce a second baseline, A2. The protective separation ends, and the child is reintroduced to the court ordered custody and visitation schedule. Rating the child's behavior continues. And there are two possible outcomes: either the child remains symptom free, which in this case, the conflict is resolved, or the child's symptoms return upon re exposure of the allied parent's influence, which represents empirically established proof of causality. The symptoms disappearing when the child is separated from the pathogenic parent and then returning when the child is re exposed to the parent, that is scientific evidence of causality. The B2 is the second intervention period. If the symptoms return, a second protective separation is initiated. This time, the causal relationship is definitively established, and the court has empirical data to support more significant protective orders. For the assessment protocol, the initial intervention period requires 6 successful weeks of cooperative child behavior. For the remedy protocol, when causality has already been established, it requires 12 weeks. So, if both cases, the child is empowered to determine the length of the protective separation through their own cooperative behavior. That's child empowerment that really matters in the court. So, I want to address the language question directly because it is one of the most common mistakes attorneys make in these cases. Stop using the term parental alienation. It has been discredited. The opposition has spent years successfully arguing that parental alienation is junk science, and the argument has worked in many courtrooms. Use the clinical language instead, the DSM 5 language. V code 995.51, child psychological abuse confirmed. Pathogenic parenting, attachment system suppression, a fixed and false belief. These are not contested terms. They're established clinical diagnoses and frameworks that the court have authority to act under the child protection statutes. The Childress Associated Clinical Designs give you observable behavioral indicators that translate directly into what a court can see and document. These are documented, observable, reportable behaviors. And the ABAB protocol gives you the empirical structure to prove causality in a way that clinical judgment cannot. So when you put all of that together, you're not arguing parental alienation. You're arguing child psychological abuse with the DSM 5 diagnosis, a scientifically established assessment protocol, and a court ordered remedy with documented efficacy. That is fundamentally different. Okay. So everything that I've just described requires a systematic approach to assessment and intervention. And that is what Protect First is actually built to provide. Protect First is a professional training and certification framework designed for attorneys, guardian ad litems, therapists, court evaluators, frontline professionals like Child Protective Services who need to quickly and accurately identify when a child is being psychologically abused, when it's occurring, and what to do about it. So the framework always starts with the assessment tool, a structured checklist that walks the frontline professional through the Childress diagnostic indicators and associated clinical signs in a systematic way that produces a clear determination. And this is helping you discern between a custody issue or a child protection issue. And it's if this, then that, a decision tree built on clinical evidence that gives you, the professional, a defensible basis for your recommendations to the court. So, from a assessment, you as the professional have a clear pathway forward. And here is what the data shows. The DSM 5 diagnosis supports this. The ABAB single case design protocol that addresses it and what the court orders need to include. That is the shift from finger pointing to clinical precision, and from the he said, she said to empirically grounded child protection. And that shift actually saves children. And how do I know? Because we implement it every single day. We work on these cases every day. And I want to leave you with a guiding principle that has defined this work for over 20 years, the work that I've been doing. We protect first, litigate second. Protect first, litigate second. When the three diagnostic indicators are present and a child is being psychologically abused through the parent child relationship, the primary obligation of every professional in the courtroom is to create safety for the child. not to manage the conflict between the adults, not to split the difference, to protect the child. The clinical framework exists, the legal language exists, the assessment protocol exists, the proven intervention exists. What has been missing is the training for the professionals who are in the courtroom with these families every single day. And that is what Protect First provides. So, if you're an attorney, a guardian ad litem, a therapist, or a court evaluator, or maybe a child protective services worker who wants to go deeper into the framework, start with the free guide. It's linked in the show notes. It gives you the complete clinical and legal foundation, including the Childress diagnostic framework, the DSM 5 language and the associated clinical signs, the legal strategy for shifting the narrative from custody dispute to child protection case. Download the free guide at the link in the show notes. And if you're ready to go further, the legal strategy package gives you everything that you need to file the protective intervention: the motion language, the declaration templates, the ABAB protocol documentation, and the clinical citations. The link is also in the show notes. I'm Dorcy Pruter, over 20 years of successfully reuniting families in and out of the legal system. I introduced this framework to professionals in family courts across the country. I've built these tools so that children in these cases finally get what they deserve. Thanks for listening.